Hello, everyone. Welcome back. I'm Anne-Marie Green. Vladimir Duthier is off today. The Supreme Court has announced today that it will hear a major abortion case this session. The case is centered around Louisiana's Republican-backed law requiring doctors who perform abortions to have admitting privileges at a local hospital. This will be the first major abortion-related case heard by the Supreme Court since Justice Brett Kavanaugh was confirmed. So joining me now with more on this is reporter Kate Smith. So, Kate, you have been covering sort of all of these laws that have been passed across the country that whether the intent is, the result is that they make it more difficult for abortion clinics to stay open. This is the Louisiana version of this law. Give us the details of what the law does and how it limits abortion providers and what the end result has been in Louisiana.
Good morning, Anne-Marie. So what's so interesting about this Louisiana law is, there's a lot of layers to it, and it takes a lot to kind of peel back and understand what's going on in this law. And I should also mention it's a very common law that you see all over the country, which is why this case is so important and could have so many implications around the country. So basically what it is it says that if you are an abortion-providing doctor, you have to have admitting privileges at a nearby hospital. So in case something goes wrong, you have a relationship with a hospital so you can immediately send a patient there. Now, I spoke to the lead attorney on the case, and here's where, why pro-abortion activists believe this is just hinders abortion care. Abortion care really doesn't need that. It's not like a back surgery or an elbow injury, something that would require PT or, scheduled follow-ups down the road. It's something that if there's an emergency, you're just going to go to the nearest ER anyway. So what the problem is that, what you see in the law doesn't really reflect medically what doctors say is appropriate.
Mm-hmm. And so what is the situation when it comes to abortion clinics in Louisiana? I know we've talked to you about other states that are, literally down to one clinic. What's it like in Louisiana?
Well, Anne-Marie, this is, again, one of those states, one of the 6 states that is down to one abortion clinic. So, this could have devastating impacts on the state, and not just the state, but the region. So, we speak so much about Missouri. But the fact is, Missouri is right next to Illinois, which has loose abortion laws, easier for women. But in Louisiana, the situation is very different. They're surrounded by other states with similarly restrictive abortion laws. So if you see this, case go through and you see the Supreme Court side with the state law regarding admitting privileges, that clinic would be forced to close.
Mm-hmm. So upon hearing that the Supreme Court is going to look at this Louisiana case, doing a little bit of reading, and I see that this Louisiana law is very, very similar to a law in Texas that was already struck down by the Supreme Court in 2016. Do you know what's, and I know you're not, our Supreme Court correspondent, do you know what's different about this law? What makes it different than the one in Texas, and so why it's being looked at now?
So that's another really interesting point about this. It is virtually identical to that Supreme Court case that you saw in 2016 that's called Whole Women's Health. And just in right now is actually a quote from the Center for Reproductive Rights. They're the lead attorney on this case. I'd love to read to you what they have to say. Mm-hmm. Louisiana is openly defying the Supreme Court's decision from just 3 years ago, in which they found an identical Texas law unconstitutional. We are counting on the court to follow its precedent. Otherwise, clinics will needlessly close, and there will be one doctor left in the entire state to provide abortion care. Now, that's from Nancy Norda, the president and CEO of the Center for Reproductive Rights.
Now, what is significant about this version of the court hearing this case is we now have Justice Brett Kavanaugh. So the court has tipped more conservative, one could argue. You speak on a regular basis to, abortion advocates. How concerned are they about the Supreme Court taking a second look at a case like this?
They're very concerned, Anne-Marie. I mean, it's, one could not argue. I mean, I think it's pretty clear that the Supreme Court has a very different makeup than it did back in 2016 when Whole Women's Health was decided. Now, earlier this year, I actually spoke to the lead attorney on this case, TJ2. Now, he was telling me Brett Kavanaugh was actually the one who wrote the dissent for this case back when they saw it in February. And, it's a 4-page decision. You can dissect it, and it's really hard to understand what his thinking is on whole women's health. That's, of course, the precedent that talks about admitting privileges, which will be so critical when the Supreme Court justices look at this case. Now, what Tu told me is that it was very hard to see what Kavanaugh's thinking is on whole women's health. It was unclear whether or not he supported it because it was the only precedent he referenced in his entire brief. So it's very unclear whether or not he supported it or whether he thinks it was wrongfully decided.
You read that statement from the attorney. I'm not sure exactly which pro-abortion rights group that attorney was representing, but, encouraging the Supreme Court to follow the precedent that it set with this Texas case in 2016. These pro-abortion rights groups have long argued that these laws, which often fly in the face of state constitutions and the Constitution of this country, are specifically designed to create these challenges that will ultimately end up in front of the Supreme Court.
That's right. I mean, there's a name for these. They're called targeted regulation of abortion providers. That's called a trap law. And I should also mention that both sides of this issue call them that. And that's right. They're designed to target these abortion providers and create these laws that would, place burdens on them that make it so difficult to, continue their work or ultimately have to close. I mean, you and I have spoken so much about what abortion care looks like in Missouri, for example. And one of the reasons why Missouri has gone down to one abortion clinic is because of laws like this, and actually because of an admitting privilege law. So they were up to 3 abortion clinics just 2 years ago, and because of an admitting privilege law in Missouri that was not challenged, or challenged successfully, I should say, they went down to just that one in St. Louis. And of course, when you're down to just one clinic, you're especially vulnerable to maintaining abortion care in the state.
So I want to ask you, because we haven't really talked about sort of the pro-life point of view on these laws and why they think they're important. In this case, a law requiring a doctor to have admitting rights or whatever at a local hospital. What's the other side of this story? What do pro-life advocates say?
Right. So pro-life advocates believe that these are laws that enhance women's health care. They are, helping women who are receiving a surgery to make sure that the medical care that they are given is as absolutely safe and good as it can possibly be. I spoke to Anne Marie Knorr. She's the executive director of Illinois Right to Life. Now, Illinois, rather than Louisiana, they went the other direction. So they passed kind of this omnibus pro-abortion rights legislation earlier this year. So if you think of a trap law, Illinois passed the opposite of a trap law earlier this year, making it easier for providers. Now, what she said, she was very upset about that, though. She considers herself a feminist, and she believes that by making abortion care easier and, having less regulations on these providers, you're, potentially making it less safe for women to receive an abortion. But the counter to all of this is that doctors say that these are unnecessary. So rather than a state lawmaker who does not have a medical background telling, providers what is safe medical practice, a doctor is saying this has nothing to do with safe medical practice. Okay.
And I should say, as I'm sort of trying to kind of identify these two groups on both sides of this very, very passionate argument, the groups are pro-abortion rights and anti-abortion rights groups, right, Kate? Just help me with the language, because I know that you've been sort of working with this.
Yes, exactly. That's such an interesting question. So the way we refer to them are pro-abortion rights activists and anti-abortion rights activists. People often use the terms, pro-life and pro-choice, but people have really kind of shed those terms because they're not necessarily, they only talk about such a small, shred of the entire argument. So actually, the way it's kind of the modern way of referring to these two different sides are those two terms.
All right. Kate, thank you very much. I appreciate that.
Thank you.